Our panel was brought together by Heritage Canada, and our mandate was not to achieve consensus. What we were asked to do was to basically talk through and reflect on what our individual views were about where the government should go when it came to online harms legislation. And by online harms legislation, I'm not talking about individual responsibility for what they post online. You know, if they post something hateful, if they are posting or sharing, for example, child sexual abuse images, something like that. This was purely focused on what are the roles and responsibilities of intermediaries or big tech or social media. And one of the most interesting things as part of this process is that we did actually reach consensus on what I would say are some of the key features of what you would want to see in online harms legislation. And I think that the first was, what specifically should be the duties of companies. And where we landed was that they should have a duty to act responsibly. This was something that the Commission on Democratic Expression had proposed the previous year. And it's almost like an approach that's product safety, right? I mean, if you're designing cars, if you're putting any products on the market, you need to think through the design and think through and make sure that it's as safe as possible. This type of due diligence approach or duty of care is emerging elsewhere. So the United Kingdom has their own version of it. That they're proposing. The European Union has just passed the Digital Services Act, which has that particular approach. And so we all thought, companies should have a duty to be responsible, not perfect, but they have to think through how is the way that we design our algorithms, our dispute resolution systems, the way that discourse flows, what is the impact of this and how are we actioning that? So that was one of the key things that we landed on. The other is that we need a regulator. We need to get this out of the courts. I mean, no one's going to the courts for these types of things. It takes years. It's too expensive. What's needed is a regulator that actually has oversight of these companies, almost like a privacy commissioner, right? That can audit companies, that can investigate them, that has the power to impose fines. And so it essentially can lift the lid on the company practices to ensure that you say that you are taking steps to ensure that there's safety in your product design. Well, show us, right? And I think that that's a key step going forward. I'm certainly of the view that this is not something should be swallowed up by like the CRTC or added to the mandate of a privacy commissioner. What we do need is a new regulator. And I think that regulator has a key role in education and in working with different stakeholders, like working with industry, working with civil society and academics to help develop guidelines. So that's my wish list of what I hope to see with the regulator. And certainly there was consensus that there needs to be some sort of regulator. And that there needs to be, I think there was a real consensus that there needs to be transparency. When I talk about the power of a regulator to investigate and audit a company, that a duty to act responsibly, well, we need to know what the companies are doing. And I think we do have a blueprint with the EU's Digital Services Act, where they have set out transparency obligations on companies and have in fact set out that there should be the right of access by certain, I guess, vetted researchers and other actors to be able to look at, say, the algorithms and the kind of a company to see if there's any sort of systemic risk. There was also some agreement on the idea that there should be a special duty to children. And, you don't want to create too many special categories. Like this is the general rule, but here's this offshoot and that offshoot and that offshoot. But it seemed that children stand out as particularly vulnerable members of society where you could justify that there should be some sort of heightened duty when it comes to protection of children. Of course, I think the money question is, well, what is that? I mean, in practice, a company is going to say, what do I do with that, right? but it might be trying to assess kind of who's using your services, who's being exploited, etc. Right? So I think that's where we landed. This is the good, right? So you've kind of got this basic framework, but there was a lot that still is left to be sorted out. And I would say that real points of friction, in my view, revolved around issues that there's no easy resolution, and reasonable people could come up with different solutions to these problems. So I'm really curious to see what's going to be proposed in the bill. One is, what do you do about mis and disinformation? I mentioned it as one of the biggest threats that we face, yet it wasn't something that we easily landed on as a solution. And part of the problem is that most mis and disinformation is that lawful but awful category. So you get into really tricky territory when you're trying to write a law against mis and disinformation. Um, there's a bit more room as you look at it as product safety. There was fears that it would be like this poison pill, right? That it suddenly it's going to tank any legislation you put forward. But many were also advocating and saying this is the big issue. You can't put forward legislation without having this front and center in it. I think that some of the other issues that we really debated was, there's a few that I'll cover before I stop, and one would be private messaging. I mean, we know it's the attack vector for sharing of child sexual abuse images. It's a great space for communication between radical actors. What do we do about that? Because privacy matters a great deal, and so does encryption, and the idea of undermining that is deeply problematic. But there is a problem here, because this is then being exploited and used as spaces for some really serious criminal activity. And there isn't an easy way through that. And, we did not come to a place where everyone really was agreeing on what to do about that particular issue. And I think that the final points where there were quite different views would be, what should be the scope of the legislation? What's in the bucket? What kind of criminal activity or other illegal activity should be covered by this legislation? Because when we talk about online harms, it could be huge. And it's really hard to think through, this legislation that would put burdens on the company that would be within the mandate of a regulator, and saying, well, that's in and that's out, right? There's no duty to be responsible about that kind of harm, but there is about this one. That's just on a principled level, that's problematic. But if this is made too broad and too wide, it will fail. I mean, it's something that could be broadened over time. At least this was sort of my view, as I thought, build it out, right? But it was really hard to figure out where it was at. I think there was a lot of criticism of the Canadian government of kind of cherry picking and saying, we are just going to look at, hate speech. We're going to look at terrorism speech, child sexual abuse images, and violence, incitement to violence, right? But there's also some principled thinking there, because it's quite a contained list. The final point I'll say is, how far down the internet stack do you go, right? Is this just applying to social media actors? Fine. Okay, maybe. Maybe it should be, right? It should just be left to that. That is really the space where most of this is happening. But when you frame it as an idea of a duty to be responsible, that duty might be different as you go down the stack, right? And we all know that when you go down the stack and you start looking at ISPs, you start looking at like the Cloudflares of the world, they really shouldn't be playing a role in content moderation. They only have blunt tools at their disposal, but they are being kind of sucked into this world at times and making decisions about it. So it becomes problematic to say, well, why shouldn't they be responsible in what they think through? Maybe their obligations are different, but maybe there should be some obligation. And that was a point of discussion that I don't think that we necessarily landed anywhere on that one. I think that there was actually broad agreement. Well, everyone should be responsible actors, but what that looked like and how far down the stack that goes is a point that was left unresolved.